Hi, everyone. Thank you for attending our webinar about how to fire someone without getting sued. We figured that this might grab your attention, but it is really important to know the risks that you're taking when you want to separate from an employee. And I will warn you that you're always going to run a risk if you don't have an HR software like HR for Health. And luckily, we are built specifically for healthcare practices and dental practices for when you want to separate from an employee. So first, I want to go ahead and introduce you to who's going to be running through everything with you today, and that is Lauren. And she began her career with HR for Health almost 8 years ago as an HR specialist, and she quickly developed an interest in problem solving through software, eventually becoming the operations manager. In this role, she recognized the difficulties of managing employees without the right tools. And now, as our product manager, she's had a lot of experience working as an HR professional, but also using technology to combat a lot of the HR lawsuits that people find themselves in. And so with all of that experience, she's going to go through these different topics today. And we're going to cover the different types of separation. There are actually different types. And two, the common mistakes that people make when firing, terminating, or separating from an employee. Some solutions that you can take with or without HR for Health. We will also give you a couple of tips, but we always want to ensure and let you know that having a electronic documentation software is the best practice overall. And then we have some statistics that we want to talk to you about and how often does this happen. I know that we used a little bit of fear to get you to register for this webinar today, but it happens a lot more than you think. Looking into the EEOC, we're seeing constant increases in people going back to their employers for wrongful termination suits. So it's best to keep yourself compliant and secure. And then we have a couple of free downloads for you at the end with the QR code. So if you have your phone near you, at the end, you'll be able to scan it and download some extra stuff that's fun for you to read, and then keep on hand so you don't have to go through each slide of this webinar to remember what we talked about today. And then we will give you our contact information as well. So we'll have a phone number and email that you can use to reach out to us. And the last thing that I will add is that although this webinar today is pre-recorded, we will have our team of HR for Health be in the chat. So please, throughout this entire webinar, send in your questions and we'll go ahead and answer them as they're happening. So feel free to type, I would say anything, not anything, but ask questions related to this webinar today. And I want to tell you a little bit about HR for Health. And our mission is to simplify HR processes and make them less stressful for businesses of all sizes. We bring to the table a combination of HR expertise and technologically advanced solutions. So that's a really fancy way to say that we have made HR for Health specifically for healthcare and for dental practices, because we notice that there's a lot of softwares out there that come with a bunch of tools that aren't necessary. We also notice that there's a lot of times that HR professionals work with small businesses, corporate companies, but it's been more helpful and useful to the healthcare sector to have HR professionals that know what they deal with, what their struggles are, and what they're looking for, and how to manage their employees. So with that, I will go ahead and hand over the super fun presentation of how to fire people to Lauren.
Awesome. Thank you, Taylor. Yes, it's definitely a hot topic. Maybe you're attending because you have a trouble employee that you're wondering how to get rid of, or maybe you're prepping for a termination, or maybe everything's good to go and you just want to know more about it if that day comes, because unfortunately, you do have a bad apple every once in a while. So we want to go through all of the common mistakes that we see. Our clients are calling in about all the time. This is always the hot topic. So let's just jump right into some basics. So there are different types of separations. So no, you don't have to memorize these. We'll just go through them. The most common ones are going to be termination and resignation. So pretty straightforward. You've all heard what a termination is. That's when you're firing an employee, so you're the one ending the employment relationship. And then a resignation is when the employee is putting in their notice. So they're the ones, saying, hey, I'm no longer going to be working here. So they're ending the relationship. Those are going to be the most common. That's what you're hearing all the time. Layoff and furlough. So these are probably more words you heard during the COVID era, unfortunately. So a layoff is basically the same as a termination. So you're ending the relationship, but it's more for a business reason. So maybe you're downsizing and you don't need, an extra dental assistant. It's more of a business reason versus an issue with the employee themselves. In a layoff, you wouldn't replace that position with someone else. You would actually want to give that position back to the person that you laid off if that was the case. Otherwise, it could be tricky and it seems like a termination and not a layoff. And then a furlough is just a temporary reduction of working hours. So this was a hot topic, hot word during the COVID times. A lot of people furloughed their team because obviously practices weren't open, so they didn't have business or work to give them. So furlough is just a temporary reduction. It's not an actual change in employment. They're still an employee of yours. They just have fewer hours during that time period. And then wrongful termination, you'll hear me say this throughout the presentation. So common things that could come up or could be considered wrongful termination is for being fired for being part of a protected class, retaliation for reporting unsafe working conditions, for reporting illegal workplace activities, for taking family or medical leave, for reporting to jury duty, reporting sexual harassment, really anything that they have a protection to do. If they feel like they were terminated for that reason, whether or not that's why you terminated them, they have the right to file that claim. So we'll go into how you can prevent that. Even if it wasn't the reason that you terminated them, you want to make sure that you can easily show that if, heaven forbid, this comes up in court. So those are just some of the foundational items, but let's jump into a lot of mistakes that we see on a day-to-day basis. As Taylor mentioned, I did start off with HR Health as an HR specialist, so I was directly taking calls from clients about termination. So I've heard all of these things. I know the struggles that you're having in your practices, so we want to just take some ease out or make it easier, so it's not as overwhelming for you. So the first one is probationary period safety net. So the probationary period is typically a 90-day, you can do whatever days you want, typically a 90-day period where you are training and coaching and getting the employee up and running. A lot of practices think that it's their get out of jail free card. So, oh, it's not working out, they're in their probationary period, I can fire them and it's not going to be a problem. So it is considered the same as any other termination. So just because an employee is in their probationary period doesn't give you a pass or get rid of your risk when you're terminating them. You want to make sure that you're still giving them feedback, coaching them, letting them know what they're doing well, what they can improve on. You want to treat it just like you would any other termination for, performance reasons or whatever the reason might be. It's not just oh, they're in their probationary period, I can fire them. So you still want to make sure that you're giving consistent feedback, you're giving them the proper training that they need. We also recommend doing 30, 60, 90-day check-ins with them. You could do an official performance review at each of those points, but even if it's just a check-in, hey, here's where you still need some more training, here's where you need to improve, and then it gives them the chance to say, hey, I feel like I need to get more training in this area. It's more of a two-way feedback, so it's not just, at the 90-day mark, it's not working out, we're going to let you go. You want to make sure that you're keeping that communication and coaching open. Okay, mistake number 2, not complying with final pay laws. So each state actually has their own final pay requirements. So that could be whether or not PTO needs to be paid out or vacation needs to be paid out. It could be the timing of the paycheck. So some states might be okay with it, the next pay period. Some states require it to be the same day of termination. So you want to make sure that you know what your state's requirements are. A lot of states also have different requirements for a resignation versus a termination. So you want to make sure you have those in place. No matter what your state's requirements are, I always recommend, especially for a termination, if you have the final paycheck in hand as you terminate them, it just avoids any confusion. You can have them sign off on a final paycheck acknowledgement form. So that's easier to do when you actually have a final paycheck in hand to give them. I know in a lot of cases, you might not be able to do that and have it in hand if there's some egregious act that happens on the spot. But that is typically best practice, is just so that you can have that signature that they received it. Another thing to keep in mind is a lot of states don't specifically say you have to pay out PTO and vacation, but they do say if you don't have an employee handbook policy that specifically outlines whether or not you pay, then you would have to pay that PTO. So let's say you're in a state that doesn't care if you pay it out or not, but you have to have a policy. If you don't have that policy in place, you actually have to pay out the PTO. So you want to make sure you have an employee handbook in general, but especially the vacation, PTO, sick leave policies, because otherwise you could be paying hours that you could have potentially avoided if you said in your handbook that you don't pay it out. So again, there's different rules for every state, like everything. Don't worry, we have you covered. We have final paycheck rules in our separation documents. And when you're running a final paycheck for payroll clients in HR for Health, it has all of those regulations linked for you. So you don't have to go and research all of that. We take care of it for you. But for those of you that aren't HR for Health clients, make sure that you're looking that up. We're happy to help you figure that out as well. Another just quick tip on this is a lot of states have direct deposit rules as well. So even though you have the employee's authorization to do direct deposit for normal paychecks, that doesn't apply to a final paycheck. So you want to make sure that you know your state's laws on that as well. It might be safest just to get their authorization to do a direct deposit for the final paycheck. But again, that's why I just suggest doing a paper check if you can, so that you can physically hand it to them. You don't have to worry about all of that. And then another tip that or another issue that we hear a lot about is deductions on the final paycheck. So maybe you gave them an advance, maybe you gave them, an allowance for a uniform and you want to deduct that. It can get risky to deduct on a final paycheck. There's state rules on this again, no surprise there. So make sure that you know what your rules are in your state. But in general, if it's a small amount, it's probably not worth, getting into hot water there. In general, you don't really want to make an employee mad when you're terminating them, because it could cause issues down the road. So if it's small, honestly, I would just consider it a wash business expense. I know it's easier said than done. So always feel free to call us if you have that issue as well. Okay, mistake number 3, failure to document. So this is really a he said, she said if it came down to court. If you're letting somebody go, you should always have documentation in place on the reason that you're terminating them. So any performance issues in general, even if you're like, oh, it's just a small thing, I don't think I'm going to terminate them for it. You always just want to make sure that you're documenting conversations that you've had with them, any issues that you've had, because if it does go to court, you want to make sure that you have the proof that you terminated them for a valid business reason and not for a discriminatory reason. So this is a big one. Like I mentioned earlier, you want to make sure that you can prove why you terminated someone. So it can't just be verbal conversations. You want to make sure that you have electronic documentation. So I'll show you in the software later on a demo of the tools that we have and some tips along the way. But again, he said and she said in court doesn't go well. The courts are very employee friendly. So even if it's just a quick, spoke to Annie about her tardiness and typing that in and making sure that it has a timestamp on it, that just those little steps, easy, simple, can help protect you down the road. Okay, the next one is over-reliance on the at-will relationship. So at-will means it's the employer's ability to dismiss an employee at any point, and it's the employee's right as well to leave the practice at any point. So either party can end employment at any point at their discretion. So the caveat there is that it cannot be for a discriminatory reason or an illegal reason on the employer's part. So at will doesn't mean that it's just, oh, I can fire them whenever I feel like it. There's no risk associated with it. There's still going to be risk. You still need to prove why you terminated them was justified and for a business reason and not for a discriminatory reason. So that goes hand in hand with the mistake number 3 that we just went over with documentation. You have to document why you're terminating and have a whole line of documentation in place so that when you do go to terminate someone, you have that in your back pocket if you need it. So we hear all the time like, oh, I'm in an at-will state, I can just fire them. I don't need to have a reason, or I don't need to have that documentation. Unfortunately, you do. You want to make sure you're always protecting yourself for worst case scenario. Okay, mistake number 5. So this one is a little tricky. So in this case, so converting a resignation into a termination. So in this case, maybe you have a troubled employee that maybe you're planning to terminate, you're thinking about it, they've had performance issues, but you come in one day and they have the resignation letter on your desk. So that's good. Resignation is always going to be safer than a termination because it's the employee saying that they are ending the relationship. Not saying it's completely risk-free, but for the most part, it's going to be a way easier scenario for you. A lot of practices will call us and say, hey, I don't want them here for the next 2 weeks. I just want them out of my practice. I don't want to deal with them. So that's fine. We just want to make sure that you're not turning it into a termination. So if they came in and said, my last day is in 2 weeks, and you said, nope, you're done today, that would be considered a termination at that point. And as we've learned, terminations are going to be a little bit riskier than a resignation. So in this case, you have a couple of options. These aren't requirements by any means. You can always tell them that's their last day, pay them on that day, and be done. There's no legal requirement to do anything but that. But it can be less risky if you either allowed them to work throughout the 2-week period. Maybe you weren't going to terminate them until the end of the 2-week period anyways, just suck it up and have them work for you. Or if you're like, nope, I want them out of my practice today, you can just pay them through the end of their notice period. I know a lot of people struggle with that one, which I totally understand because you're giving them pay for time that they're not actually working, and you might already have a frustration towards them. But those are the 2 options to keep it a resignation. So you can either allow them to work throughout the last 2 weeks, pay them as normal, or you can have them not come back in and pay them through the 2 weeks. Again, those aren't requirements, it's just to lessen your risk. You can keep it as a termination if you just wanted to say, okay, no, you're done this day, here's your final paycheck, and keep it at that. Again, if you can keep it a resignation, then that's gonna make it safer down the road. So if you ever get into this scenario, keep those things in mind. Okay, mistake number 6, dismissing a member of a protected group. So if you've called us before the termination, you've probably been asked those 3 questions. Are they pregnant? Are they disabled? And are they older? So these 3 groups are always going to be higher risk. Again, doesn't mean that you can't terminate them. It just has a little bit more risk associated with it, especially, if someone is currently pregnant and you want to terminate them, that could be very risky. Maybe they were previously disabled on disability leave and now they're back, but it's only been 3 months since they've been back. That would still be considered risky because it could be considered retaliation for that disability leave. So just these things to keep in mind. Our team will talk you through it and make sure that you're covered. If needed, we'll refer you to our sister law firm to get a consultation to talk through your risks and what your options are. But these are always going to be the 3 riskiest areas. And then in terms of what's considered older, which might sound crazy because it is a little crazy, is anyone over the age of 40. So the established age there is very young. So you might think, oh yeah, no, they're fine. They're only, mid 40s. They're not old, but it can be risky. So just something to keep in mind. If you hire them when they were already over the age of 40, there's less risk there because you can show like, oh no, I hired them over that age and now they're just having performance issues or whatever it might be. You just want to avoid, maybe you hired them when they were 25 and now they're 45. You don't want it to look like you're terminating them because now they're over that age. So that one's a little bit, it's not as risky, but it's still one of the factors that we consider. Pregnant and disabled are definitely high risk. So you want to make sure that you're taking extra precaution in that case. I should have mentioned this at the beginning of the slide, but go ahead and scan this QR code. There's something called the Pregnant Worker Fairness Act. If you missed our webinar on this, I would recommend going back and watching it. It's really just going over all of the new protections in place for pregnant employees, accommodations that you have to make for them. So make sure you know that what your requirements are and what the interactive process looks like if you do have a pregnant employee. So highly recommend going ahead and checking that out now. Okay, number 7, over communication. So if you have nothing nice to say, don't say anything at all. It's the rule we learned in grade school, right? But when you are conducting the actual termination, so you're sitting down with the employee to tell them that they're terminated, you want to make sure that you're keeping it as concise and objective as possible. I know it can be a very emotional time. You might be very frustrated with them, whatever the situation might be. It's not a fun experience, of course, but you want to make sure you're not giving them, bombarding them with a laundry list of reasons on why they were the worst employee ever or all of the things that you didn't like about them. So you want to keep it very short, sweet, to the point. You should, of course, give them the reason why you're terminating them. You shouldn't just say, we're letting you go today. Bye. You should give them a general reason, but you shouldn't list out, here are the 10 reasons why we're terminating you. So for example, if you're terminating someone for poor performance, you could say you didn't meet the performance expectations of the practice. So very clear and to the point. You're not listing out a million things, but you're still giving them the reason. If you're terminating them for, an outburst, or, maybe they caused a huge scene in front of patients, you could say that you're terminating them for employee misconduct. A lot of these situations, you could probably quote your employee handbook as well. Again, just keeping it as objective and business specific as possible and trying to leave that emotional frustration at the door, which I know is a lot easier said than done. So just take a breath before you go in. You can do this. Okay, quick little bonus tip. So we have the 7 mistakes, but the last one is about disputing unemployment claims. This is another situation that people feel very emotional about. You've terminated someone and now they're applying for unemployment. You don't want them to you don't think that they deserve to get the unemployment. They did X, Y, and Z wrong. Why would I pay them for being unemployed? Again, I know it's hard and it goes against your intuition and what you want to do, but we don't suggest fighting an unemployment claim. So again, it's a very emotional process, but we think about it as a soft cost. So you're already paying into your unemployment bank. This is if you're in a state that has an unemployment insurance program, but you're already paying into that bank through your taxes. So if an employee files for unemployment, you're not paying anything directly out of your pocket at that time. Their taxes are already going into that bank. And why we recommend not fighting it is you don't want to create a disgruntled employee or upset an employee further. Again, it's not additional money coming out of your bank, so let the state handle whether or not the employee is eligible for it or not. Typically, if you've terminated them, they are going to be eligible for it. So we suggest just letting them have it. Of course, if it's something egregious where they were embezzling from you, then of course you might have more of a reason to fight the claim. But in general, if it's just a performance issue, then we suggest just letting them have it. Of course, give the state all the information that they need, give them the facts, but we suggest not fighting it. So again, I know that goes against intuition and it's hard to do because it's an emotional thing, but we don't want to cause more problems with the terminated employee. We just want to let them go on their way. Okay, so enough about all of the mistakes that are possible. Let's go into actually how you can do all of this. So let me go ahead and pull over the software for you. And I'll go ahead and show you a few of the tools that we have in place to help you with all of these mistakes. Okay, so today we're going to go ahead and do some documentation for our test employee, Annie. So under this performance tab, we have her violations and her performance reviews. So first I'm going to go ahead and show you violations. Again, this is going to be crucial when you are going to terminate someone to avoid the he said, she said if it goes to court. You want to make sure you have this documentation in place. So you can go ahead and click add violation, the category. So maybe it's attendance, tardiness, conduct, whatever it might be. You can put that category here. Type formal, informal, and private. So private is if you just want to document something, but you don't necessarily want to draw it to the employee's attention yet, or maybe you had a conversation with them about it, which we highly recommend, but you don't want to have a formal documented violation for them to see. You can click private. It's still in their account, has all the information with a timestamp, but the employee can't see it. Informal might be, one of their first offenses. You just want them to be aware that this is a problem that they need to improve. So you can send them an informal. A formal is kind of like a last warning, like this is our last straw. We've talked about this. We're getting close to termination. So it kind of just tells the employee the severity of it. Description is just a high level of, what the violation was. Maybe it was, Annie's been tardy 3 times this month. We've talked to her about it, 4 times, whatever it might be. And then under here, there's some additional options as well. So you can put a specific time. Maybe there was an outburst and you need to document the actual time that it happened. The rule or policy that was violated. This is a really good area to copy and paste your handbook policy if you have anything that's applicable. So maybe it's attendance, so you want to copy and paste your attendance policy here. Correction plan, if there's any specific steps that you want to enforce with the employee for them to take in order to correct the behavior. And then anything else worth mentioning, again, just a generic box where you can add any additional information here. We also, for current clients, we have a save as draft option. If you've completed it, but you don't necessarily want to send it to the employee yet, your work is not lost. So go ahead and click that save as draft. And then when you click complete, it's going to send to the employee for their signature. So the signature is important because it's showing that they're acknowledging that the violation was received. So this one is just important, again, just to make sure you have everything documented in writing. We have the timestamp, when they received it and all of that. Performance reviews don't always have to be a negative thing. They oftentimes are a very positive thing. So don't think that I'm, telling you just to do performance reviews for your bad employees. You want to encourage your well-behaved, good performing employees as well. So highly recommend doing performance reviews for everyone. But with this webinar, obviously we're talking about termination. So especially if you're terminating them for poor performance, you want to make sure that you have a performance review on file showing this. So for example, this is one of the performance reviews. If you click view, so this one hasn't been completed yet, but you can get an idea of what it'll look like. So this is completes tasks on time. The manager, so I'm the manager, I would review for the employee, and then the employee would actually do a self-review on their own performance. The nice thing about this is you can see really where there's a mismatch or a disconnect. Maybe the manager's like, nope, they're not performing well at all, and the employee thinks that they're perfect. Obviously, there's some communication that needs to happen. They need to be clearly defined on what they need to improve on. But in general, this just is great for documentation on what the employee is doing well at, what they need to improve on, allows you as the owner or the manager to coach them on what they need to improve on. Again, just keeps that open communication in general. And then worst case, if you do need the documentation, you have that to show, hey, they had a really poor performance review, a month ago. We tried to work with them on X, Y, and Z, and it just didn't work out. Another really popular feature that we have is the notes section. So the notes section can be used for anything. You can use it to say Annie's favorite color is purple. Her favorite cake is funfetti. So it doesn't necessarily have to be for performance or violations or documentation. It's anything you want to use it for. The employee cannot see this page. So this is purely for you as the manager or the employer to document anything that you need to for the employee. A lot of clients will use this for conversations that they've had with the employee. Maybe it's not necessarily a formal violation, but you want to make sure that you're documenting it with a timestamp. You can click this add note and you can put in whatever you want here. Sometimes they'll, copy and paste a text exchange or an email exchange, whatever might need to be in the employee's file for future reference. Again, the nice thing is you can see when it was created. So if it ever came down to it, you can see that you weren't trying to just build up the case right before you terminate an employee, because obviously that's going to cause issues as well. If you terminated them yesterday and then you're adding all these notes today, it could seem like you're fabricating them. So that's why the electronic timestamp is always going to be beneficial. And having these notes is really helpful. So again, this can be used for, informal violations, maybe to just document general situations that happened, general conversations that happened, anything really that you want to keep on file for this employee. They can't see it. So it's really beneficial. You can really use it however you want. The last thing I wanted to go over pretty quickly is the separations document section. It's based on the state that you're in, and then you can select which type of separation it is. So some states have requirements for termination documents versus resignation. So you can select which one it is. You can see if it's mandatory or recommended. I mentioned final pay regulations. So we do have a document for each state that outlines when you need to pay, what you need to include on the pay, what the penalties are. So again, just takes all that guesswork out of it. You don't have to be Googling all of those things. Cool. So those are just some high level features on how we can help you keep all this documentation in place and making sure that you are protecting yourself. And then of course we have our HR specialist team as well. Every situation is unique, so always feel free to give us a call and talk through those things as well. Perfect. So we'll jump back into these slides. So some considerations. So what next? What do you need to do to make sure that you're protected moving forward? The first one is to create a process for documentation. So how are you going to document violations, performance reviews, conversations that you're having with your employee? Make sure that you have a plan that you can establish throughout your practice. The next one is to know your state's laws for final pay. So when do you have to pay the final paycheck? What do you need to include on it? Can you do a direct deposit? How do you handle deductions? All that. So make sure that you know what your state's laws are. The next one is your state's final paperwork. Again, I just showed you there's different documents for each state. So just make sure that you know what you need to provide to your employees. And then the next one is obviously we're going to have the employee handbook in probably all of our webinars because we think it's that important. But really it outlines all of the expectations that you have for your team. But also, as I mentioned, for PTO vacation, you want to be really clear what happens at the time of separation. So especially if you're in one of those states that if you don't have a policy, you have to pay it, having the handbook really could save you money in the long run. So you should have a handbook no matter what, but if saving money will motivate you here, then I'm happy. Whatever will get you a handbook. We've done plenty of webinars on our handbook software, but if you have questions or want to see our handbook software, feel free to reach out. It makes it super easy where you can just have a handbook generated right after you fill out a questionnaire. It's always going to be updated based on your state. So if you have questions there, always let us know. And then the next one is ensuring you have clearly defined job descriptions. So that's going to be crucial, especially if you are, terminating someone for a performance reason. You have to make sure that you have clearly outlined what is expected of them. So making sure that you have a job description from the beginning that you can always refer back to is going to be crucial for any performance issue, any termination. So make sure you have those in place. We do have preset job descriptions for all of the healthcare industries. So we already have those for you. You can customize them based on your practice. Obviously, every practice is different and unique, so you can customize them, but we have the base job description for you, so you don't have to do all of that Googling work yourself. And then the next one, of course, if you have managers in your practice, you want to make sure that you're training them, one, on all of the things we just discussed, but also on how to coach employees. So if someone is having a performance issue, how to coach them on how to improve, just coaching them in general on how to follow all of your new protocols that you've put in place. So I know it's a lot. We went over a lot today. This is obviously, you can rewatch this at any point. Reach out to us if you have any questions, but hopefully this helps with what you need to do next. But with that, I'll kick it back to you, Taylor.
Sorry for the awkward pause. Thank you, Lauren. And here, there's another QR code that we want to offer you for this 2023 State of HR report. We surveyed more than 1,500 healthcare practitioners in the dental industry, optometry, chiropractic, and more. And with each of these surveys, we found a lot of data. And if you're not the biggest fan of reading reports, that's fine. You'll find some really big numbers that'll point out or stick out to you that you can read and see that you're probably not the only person experiencing the issues that you are. And this will also show you why we've created HR for Health and why it's so important to have an HR software for those that are in the healthcare industry. And then the last thing
It's really good. I just have to chime in. It's a really good report. It sounds like, oh, HR report might be really boring, but there's some really interesting and fun things in there. Obviously, we're biased, but just had to put my 2 cents in there.
And it's gorgeous.
And it's gorgeous. We make HR fun.
Right. And then the last thing for today is, I know, another QR code. So the last one, though, is going to be a little termination guide, like infographic. If you are a super fan of HR for Health, you'll remember that we've had one for quite some time, but we've gone in and updated the design and the information on that guide. So please go ahead and re-download this. It's free. And it's just something for you to have on hand. If there are any questions that you think of after this presentation, please email us at hello@hrforhealth.com. You can visit our website, you can give us a call, but if you're like me, I don't believe in making phone calls, so you can just email us and we'll get back to you really quickly, and just let us know what your thoughts are, if you want us to follow up with you, and if there's anything that you just forgot to ask while you were listening today. But thank you so much for registering and giving us your time. We hope that you enjoyed the information, even though there was a lot of it. I'm sure you learned at least 1 or 2 things that you didn't know before. So think twice before you fire your employees. And thank you, Lauren, for all of your insights today. And we look forward to seeing you all soon.